Good evening, everyone. I'm Julia Gorman. Welcome into Evening Plus. I'm joined once again this week by our Lauren Baker as we continue to recap for you the trial of Christopher Schurr. He is the former Grand Rapids police officer accused of murdering Patrick Loyola 3 years ago. Just in the month of April, it was 3 years ago exactly. So lots to get to. Lauren, it was another really busy day of testimony. All of the witnesses today called by the defense. That's where we are at this point. Any big moments that stood out to you before we kind of dive into everything?
You know, I think the biggest thing is obviously the expert on exercise. Things got tense a little bit between him and Prosecutor Becker. Almost the opposite of, the same thing, but in reverse with Stoughton and the defense, you know, that kind of just reassurance that he was giving the defense. So I think that was one testimony that stood out. Also, I talked about this in our shows. Technically, Prosecutor Becker, is the chief law enforcement officer for the county. And he was asking GRPD a lot of questions about their policy. And attorneys I talked to said he should know that because he is the one in charge of them. And it's not to say that he doesn't, right? He probably does know those things. But it was interesting to see him cross-examining basically people who he works with to police our community.
Yeah, that's a really interesting point. And we have our Callie Lichter and our Riley Mack live outside the courthouse now. Once again, ladies, thanks so much for being with us. I want to start, before we get into each testimony today, something that we have seen, and I was just talking with Lauren about this, is jury questions. We've seen a good amount of jury questions asked. And for someone who may not be familiar with what that process looks like, Callie, maybe we can start with you on, what that's been like to hear those questions and kind of how that process works.
Yeah, so for the viewers at home who may not know, we're seeing the same exact thing, Riley and I, inside that media room as people are on the stream. So, we're not allowed to see the jury, we're not allowed to hear the jury. It's just to protect their anonymity. And so when a juror has a question, I believe they raise their hand and then the judge acknowledges it. And it kind of comes towards the end of questioning when the prosecution and the defense wraps up. And then for us and the viewers at home, you could tell the audio goes silent as someone goes and collects what I believe to be maybe like a Post-it note, piece of paper, whatever they wrote down this question on, to bring it to the judge. And then the judge really decides, Christina Mims, if the question is one to be asked or if it's not. We've seen a few questions that have not been asked in during the trial while the jury is in the room. And usually those questions that haven't been asked, there was one, I believe, that was asking for a break, saying that, the jury members need a break. And there was another question earlier today about, I believe it was reasonableness, like a reasonable officer question, a term that we've been hearing a lot throughout the trial. And the judge said she didn't ask that question simply because she didn't believe that the witness could attest to that or, could speak on that. So I think these juror questions are really telling. A lot of them are calling back from testimonies that we've been hearing on day one, day two. And, it's their job to take notes, to pay attention. But I think it really shows and proves that they are, in fact, doing that. They're remembering things. They're asking questions, trying to piece together at this point, probably nearly 20 witnesses that we've heard over the past couple of days.
Yeah, I appreciate you guys walking us through that. I think that's something that may stand out to folks. Lauren, you were saying that is something that exists, or not so much exists across the country, but is the way that things are processed here in Michigan, which I think is interesting and why some people may not be familiar. Testimony started off today with Captain Cyber with GRPD. Once again, his testimony continued from yesterday. And what we saw, and ladies, feel free to chime in here, it was a lot of the same topics as yesterday, talking about the use of the Taser, talking about police policy compared to national policy. And of course, that question that's being proven by each side here, was what we saw happen 3 years ago reasonable? The first, new witness we saw called to the stand today, another police captain with Grand Rapids Police, Chad McKersey, and he was an expert on several topics. Again, we saw what I was just mentioning kind of gone into there. We do have a clip of his testimony that we can play first.
Does the officer always have to use the best tactic or make the best decision in that moment to still be deemed reasonable?
No.
Does it depend on the circumstances? Is that what you're explaining?
Yeah, it's it is a very dynamic, evolving event. So there's a lot of things that go into that factor. We have to weigh that stuff in judging the reasonableness of that action.
And Riley, I'll maybe let you sort of take this one. You know, the topic of what is reasonable is something that, of course, is the premier topic in the trial. But we've seen different answers from different people called to the stand on the answer to that question. Your take on all of that as we saw it brought up once again.
Absolutely, yeah, Julia. I think yesterday, or on Tuesday actually, we heard from the prosecution's witnesses, his experts, Seth Stoughton and Nicholas Bloomfield, who spoke on, you know, what a reasonable officer would do in terms of general police practices. Today we're hearing more from GRPD specifically on their policies and how those policies kind of reflect what officers should do in the field. So we're learning about, you know, the specific GRPD policies that that potential officers are taught in training and how that can reflect on their behavior. I think the biggest takeaway that I got from McKersey's testimony about the Taser is, you know, Becker asked specifically, is there any specific language on, you know, escalation from a Taser to a gun in a struggle with a suspect? And there's no language on that policy. That policy doesn't exist, McKersey said. So we're just learning more about the specific language that officers are taught before they enter the field.
And something else that stuck out to me personally that I feel like maybe folks at home could be noticing is, and it makes sense obviously when you're hearing from the defense versus the prosecution, is the language that's used surrounding the Taser and explaining what happened with the Taser. It almost can get confusing because, of course, from the prosecution's point of view, you know, they're talking very lightly about what exactly happened with the Taser, whereas the defense is really using that as an argument to, okay, you know, allegedly Patrick Lilley had a control of the Taser, and therefore that's why we saw the use of deadly force. So it's two, you know, understandably very different sides to that story. That was something brought up once again in Captain McKersey's testimony. We have another clip on that.
Would it be reasonable for an officer, when an individual has disarmed them like that, to fear that the individual may use the weapon on them?
Yes.
And is there anything noteworthy in that video that takes place just prior to Officer Schurr drawing his weapon?
At that time, the suspect in this incident had complete control of the Taser and had switched it from his left hand to his right hand.
And how about the positioning of these two persons just prior to the firearm coming out?
It appeared in my review that Mr. Leroy was getting back up and turning towards Officer Schurr at that moment.
Okay. Would an officer, with the training that Officer Schurr had, would it be reasonable for that officer to be in fear that the individual may use the device on them under the totality of the circumstances?
Yes, based on the totality of circumstances, that everything that's portrayed so far at that moment, there would be a reasonable fear of another officer at that time of great bodily harm or death.
And if an officer reasonably fears serious injury or death, does that officer, are they required to wait for the individual to actually aim the device at them?
No.
Because what happens when somebody aims a device at you?
Action's faster than reaction, so we don't have to wait for someone to hurt us to do something.
If there's reasonable fear, serious injury or death, what level of force is the officer authorized to move on to?
Deadly force.
And of course, you know, those are the questions that we continue to hear over and over again. It did feel as though, you know, a lot of the same questions that we heard yesterday were once again the topic today. You know, when we saw so many from Grand Rapids Police yesterday and moving into today. Anything else from maybe Lauren, starting with you, just about what we've heard so far?
I think the biggest thing that, and you'll probably have a clip on this later, is that, you know, when we hear about policy, I think the reason why they're honing in on policy, or well, actually they say this, it's because they're trying to figure out which policy Schurr was supposed to follow that day. One of the questions that was later asked was about should they be following the nationwide policy that's kind of like the umbrella for everything, or should they be following GRPD?
Right.
And it comes down to that they should be following GRPD. And so that brings into question, what Stoughton was there, the expert for the prosecution was saying that, Schurr didn't follow these policies. Well, technically, if he's supposed to be following what GRPD has for their policy, the defense is saying that he did what he was supposed to do. And it's important to know that those policies are reviewed consistently by an accredited association. So it's not like not only was he not following policy, but he was doing the wrong thing. And in all actuality, what the defense is saying is he was following a policy that has been approved by the nationwide umbrella of policies for police. So I think it's an interesting take to kind of bring a full circle back to, did Schurr do the right thing that day?
And we hear that brought up a lot, GRPD policy versus kind of universal police in America policy. And we heard arguing today, during testimony too, about, the date that certain policy came out. We heard that from Prosecutor Becker on, what is most up to date? What was Schurr trained on, that he would have or would not have been using when this incident happened. And we then saw Prosecutor Becker, of course, cross-examine Captain McKersey. Here's a clip from that piece of testimony today.
Once again, going to this Taser thing we talked about, all of a sudden we're getting this, the Taser's taken away, that's deadly force, that justifies deadly force. Where is the policy for that? Where is that?
Again, you're looking for the black and white answer. It's the gray area. It's the totality of the circumstances at that time. So part of the reason we do voluntary exposures is to know how this device affects you, and so the level of pain, the level of exhaustion. Add that to the totality of circumstances of extreme exhaustion after a 2.5 minute fight, and it's not written down. It's the totality, and that's what we're going over.
And that's what I'm going for. So it's not, there is no, hey, Taser's gone, you get to shoot him, right?
Right.
It's based on, you gotta take a look at all the context, looking at the whole situation, right?
Correct.
And then you make that judgment call, not on the basis of hindsight, but what would a reasonable officer know at that point in time?
At that time.
Again, it felt very repetitive in many moments today, but it's really on honing in on that point that each side is trying to point out. Callie, I'll send it to you on this, and that is, we saw some questioning today and also yesterday concerning, policy or what is acceptable when it comes to where on someone's body you're shooting at them or aiming to shoot them. And I've got a clip I'm going to play in a moment when they were particularly talking about headshots, shooting someone in the head, which is, of course, what we saw happen with the situation involving Patrick Loyola. I think this is something that maybe a lot of people at home aren't super familiar with what is allowed, what is trained, what is taught. Can you speak to that at all?
Yeah, so we kind of got two answers on how GRPD trains, to use the firearm, to discharge the firearm, and that was also part of a question from a juror. It was a juror question that we heard earlier today, but GRPD's policy, there's kind of like two things just in general. They're aimed to either, shoot kind of the largest area they can and to, eliminate the threat, to stop someone from doing a certain action. And that may, unfortunately, in some circumstances, include a headshot. They said they're trained to shoot what they can to stop the threat from happening. And you had a juror who wrote a question, something along the lines of, if someone's holding a gun or a taser in this circumstance, why shouldn't the officer just, shoot for the hand, shoot for the arm, shoot for something in the general area on where, you'd be holding some type of weapon? And the answer that was given is that, that area's small and it could be a moving target, but rather, a larger mass would be easier to shoot. And again, they said sometimes, unfortunately, that does have to be a headshot.
Yeah, and we've got that clip from from Police Officer Jason Gady. We can play that now here.
If an officer decides to use their firearm against a deadly force threat, where are they trained that they may need to target?
Available target areas with the intent of stopping the suspect's actions as quickly as possible.
And not very pleasant topics, okay, to talk about, but you're a firearms trainer. Are headshots acceptable?
Yes.
And is that actually a target that's trained upon at times?
Yes.
Is an officer trained, if the officer perceives they might be in a deadly force situation, are they trained that they should fire warning shots?
No.
To see if, experiment to see if perhaps that may help their situation?
Absolutely not.
Is that allowed? If you can just elaborate, is that allowed? at
No,
all?
no, it is not allowed or advocated.
If an officer may be in fear of serious bodily harm or injury, are they trained that they should perhaps try shooting to extremities or other parts of the body to see if perhaps that may alleviate the situation?
No. No.
Are they actually advised not to do that?
Yes, for several reasons.
But what's one of the main reasons? If,
One of the main-
if you have
again-
an imminent threat and you
Trying to, again, stop the subject's actions as quickly as possible.
And that was what I was going to bring up there was, I'm sure there's folks out there who thought, why not, shoot in the foot or shoot in the hand, the hand that the taser was touching. And ultimately, this officer who heard from and others testified to the fact that that's not what they are trained and instructed to do, because it's to get rid of the threat as soon as possible. Moving on from Gady, we then heard from Robert McFarland, who we heard from the prosecution called, and this was the first witness we saw then recalled to the stand by the defense. And once again, same topics talked about. We have a clip from McFarland that we can play now.
So this particular exhibit is two RFNs from two parts of the incident, because we lose some of the action between these two. And right here we see Officer Schurr has the taser by the hand grip of the weapon, and Mr. Leoya has the, well, just for lack of another term, the other end. And he's got it with his left hand. The next exhibit is RFN 6211. And this is where we see Schurr still has the taser in his right hand, but now Mr. Leoya has it in his right hand.
And once we moved on to the next witness today, which was a man named Lon Bartel, former police, but an expert on a number of topics. This is when we really got in to the topic as a whole of exertion and exhaustion. And this was harped on for quite a while during testimony. Lauren, can you kind of walk us through some big points from that moment?
Basically, what he's just saying is that Schurr was exhausted. He talks about at extent, what happens when, your body is really tired and how you get there. He kind of compared it to, your body's not used to having to fight someone like that every day. Same reason as to why if you wake up one day and say, I want to run, a 5K, and you've never ran that long in your life, you have to train to do that. If you wake up one day and say, I want to be a power lifter, and you've never lifted heavy weights, you have to work on that. So he was kind of just trying to put into the juror's perspective of, he was tired, and we hear it too. He talks about, you can hear him exhausted, you can hear him tired, and thinking about how that connects to the mental capacity that Schurr had that day and making that decision. And it was interesting to see because, obviously this is something that we haven't heard argued in this case yet. And so it'll be interesting to see if the jurors take that into account, that he was extremely tired during that.
Yeah, and it was brought up a lot as well, just sort of the upper hand that the defense, those who testified, during defense questioning, the upper hand that Leoya had in comparison to former Officer Schurr. Before we move on from that, I do just want to play a clip that kind of spoke to what Lauren was just mentioning.
Would it be reasonable for an officer in a similar position that, after he had been fighting for over 2.5 minutes, when he was after being disarmed of his taser, after being outnumbered by other people that are there, would it be reasonable for an officer to be in fear of serious bodily injury or death?
Yes.
And Callie, I'll send it to you at this moment. This was, a new topic that we heard about quite a bit, that exertion and that exhaustion argument that ultimately led up to that questioning we just heard about, that playing a role or being the role in leading to using deadly force. Your take or any other details about that line of questioning?
Yeah, so, this was a very different type, like you were mentioning, a very different type of witness than we've seen before. And kind of the first one that we saw Kent County Prosecutor Chris Becker push back on his ability to be an expert in this case. Becker was kind of saying how his expertise was outdated. It's not in this field. He shouldn't be considered an expert in this case on what he was testifying about. But the judge eventually, ruled that he was okay to be an expert in this case. And so for, the first part when he was being examined by the defense, he talked to what was played in the SOT, what was being said, throughout this evening, that, he was exhausted. He had no other options but to use deadly force. But I think that the really interesting part of this witness came during the cross-examination and kind of the things that Becker brought up about his thoughts on the use of deadly force and handguns and some of the previous things that he's written about. And so I think he was a very controversial witness, especially for the prosecution.
Yeah, I know there were specific articles and posts and things that were brought up that certainly got a little bit contentious between Prosecutor Becker and Bartell. And then we moved on to the final witness of the day, which things also got a little dicey, if you will, on the stand. That was Mark William Kroll, not a police officer, but considered an expert in the field of operations effects of electrical weapons. We have a clip from him. It was once again brought up, this topic of the transition from the taser to the gun and, what the rationale could have been for moving from one to the other and kind of what the rationale or the statistics are across the country when you move from, one tool to the next. Here's that.
Sadly, what happened here happens every month or two across the country, because Taser electrical weapons are used about 2,000 times a day worldwide, about 1,500 times a day in the United States. It doesn't always end well. It doesn't always do the job. And then so there's a transition to firearm. And over a 20-year period, there have been over 1,000 deaths where the Taser electrical weapon failed to control the situation and the officer moved to lethal force. Of those, we've looked at the very particular issue of the suspect taking control or attempting to take control of the officer's weapon. And as of 2020, there were 113 such cases. And there were 53 of those cases. The officer then transitioned to the firearm and shot the subject. 48 ended in a fatality. 5 led to non-fatal wounds. And that was published in 2021.
And this witness, again, the one who ended, time on the stand today, things got heated at the end with Prosecutor Becker. What stood out to you about, he was hounding him with questions.
I think what was interesting and what stuck out to me is Becker wasn't really questioning his expertise per se in regards to maybe taser use, but but he was kind of going at him about its relation to police training.
Right.
You heard Becker say, you can't compare this to police training. You're not an expert on police training. And Kroll at one point did say, you're right, I can't speak to that.
Yeah, he agreed with him.
But it was interesting to see how Becker again was trying to kind of tie into, well, you can't speak on this because that's not your expertise. And he is a scientist. He can speak on the impacts of a taser and what they can do to people. But it was interesting to see how Becker tried to tie that together.
Especially when it came to the statistics regarding, when we see a taser used, when we see that move to the use of a firearm and the deaths that happen. Obviously, that is a critical piece of this entire argument. I have one last piece from his testimony to play, and then we'll send it back out to you, ladies. Let's play that first.
There's still never been a police officer killed after being disarmed with a taser.
Well, yes, and that speaks to the effectiveness of the policy.
You keep talking about a policy, you don't know anything about a police policy. Your impression of a police policy is not a policy, right?
Okay, I guess what I can see, that's a fair point.
Okay,
Well,
so
we-
that's your impression.
but
You're
the-
not- You gotta stop. You don't know anything about police policies or practices. So all you know is no officer has ever been killed in the history of the Taser after being disarmed with a Taser, correct?
And I don't mean to be
And it kind of continued from there. I kind of clipped you there because things just kind of went back and forth after that. There wasn't really a firm answer to that question. The defense got involved, the judge got involved. Callie, Riley, you know, this was how we ended testimony today. How did you take things as a whole that we saw in day 4?
Yeah, I think, well, ending like that, it feels like a lot of the same story that we've had so far with the Taser experts of, you know, the prosecution, the defense establishes that, you know, Tasers can be deadly weapons, they can be dangerous, and officers, GRPD officers specifically, are taught that when they're trained to use a Taser, that they can be deadly. They're given the warning that says can cause serious injury or death. And then the cross-examination happens and the prosecution, you know, says, yes, while it can be dangerous, those cases are extremely rare. Like in this cross-examination with Kroll, Becker brought up how out of 1.4 million cases where a Taser is used, 12 caused a death. 1% of those cases out of 1.4 million hit someone in the face, and even less than that hit someone in the eye. So, you know, it's been the same story with every Taser expert so far, where we establish Tasers can be dangerous, and then we establish, yes, but those cases are very rare.
And I just feel like, you know, we kind of know what we're going into now. We're kind of in a pattern of it, even though, you know, some testimonies can be a little more surprising than others, some surprising response from, you know, both sides. We know that when the defense was going to call in witnesses, we knew when the prosecution was going to call in witnesses, you know, they were going to be supporting their side of what they're trying to prove and argue. Again, you know, the defense doesn't have to prove anything because Schurr is innocent until proven guilty. The burden is all on the prosecution. You know, they're still going to call in experts like the several that we've heard over the past 2 days to try to prove that this was self-defense on Schurr's part, or I guess argue rather, you know, self-defense, and that he was scared and he ran out of options. I think we definitely heard that from the witnesses that we saw today. You know, he was scared, he was alone, they were understaffed. The only thing that he could do was what he did, and that's according to the defense and their witnesses.
Yeah. I appreciate that analysis from you, both of you ladies. And, you know, tomorrow we move into day 5. We don't know the exact schedule of how many more witnesses we could see. And, you know, if, you know, 2 witnesses that would, of course, garner a lot of attention is, will we see Schurr himself brought on the stand? Someone else who we have not seen called, you know, current police chief Winstrom, you know, could he possibly be called? You know, those would certainly be 2 striking testimonies. You know, kicking into tomorrow, you know, the defense has not rested just yet, but I mean, again, nobody has a crystal ball in this situation. Mm-hmm. Could we see that happen tomorrow? We just don't know yet.
Yeah, it'll be interesting to see what they decide to do. You know, like we've been talking about this whole trial, they have 40 witnesses called. And also the pacing of those witnesses, right? When we saw multiple GRPD officers back to back to back, they were on the stand for what? 2-3 minutes, maybe 5 tops. It wasn't very long.
Right.
But then we did hit some people that they were on the stand for a really long time. So it's really hard to say that if they say, okay, we have 6 more people, that doesn't necessarily mean it's 6 more days or,
right,
you know, just 1 more day. We really don't know the pace. So it'll be interesting to see what they decide to do.
And we've seen some witnesses where there is extensive cross-examination, and then others where it's no questions, mm-hmm, Your Honor. I do just want to say thank you to Callie and Riley for joining us once again on Evening Plus and providing all of that analysis. Riley is the woman behind our really incredible live blog that we have going all day long. So if you're not able to watch our coverage, you can always read through it with really great minute-to-minute details. Callie, of course, providing our live shots throughout the day alongside Riley as well. So ladies, thank you so much, and we will talk with you both again, of course, tomorrow at this time. Bringing it back here, you know, Lauren, you will once again be streamlining our streaming coverage tomorrow, starting bright and early, and you know, no one really knows what tomorrow will bring. We'll just have to wait and see.
You know, it really doesn't. And one thing that experts have constantly kept telling us is that you really do have to wait to the end of the case. You can't look at one day and say, oh, you know, the defense won because of this and that's why, and vice versa. And it's not up to us, right?
Right.
We're not the jurors. It's up to the jurors and what they decide. And so it'll be interesting to see what happens. But, we still have another day.
Another day, and we will keep you posted. Lauren will once again kick off our streaming coverage early tomorrow morning. I'll have kind of a smaller recap for you tonight at 11 o'clock of what we saw happen. But until then, we will be right back here live tomorrow at 6:30 on 13 Plus. Thanks so much for joining us. Have a great Thursday evening.